Antonia, up until this point here, we've gotten to the point where we've submitted the offer. Now let's say the offer is accepted. What next? What's the legal requirement at this next stage with regards to, say, cooling off periods, etc.?
Okay, so Angelo, once a vendor and a buyer have entered into a contract, a vendor then also needs to provide a document known as a Form 1 or a Section 7 statement under the Land and Business Sale and Conveyancing Act. So I'll just quickly explain what a Form 1 document is. It's under the Land and Business Sale and Conveyancing Act, it's a prescribed form in terms of the content and the information that it needs to outline. It's set out in legislation. So there's no way that you cannot provide certain information. And it covers a range of information that is relevant to the property that a buyer is considering purchasing. So for instance, it will outline the title details of the property, it will outline any restrictive covenants, easements, mortgages which may be registered over the property, whether for instance a neighbour has issued a fences notice, whether, for example, if some sort of an addition or a renovation has been made to the home, there may be some ongoing conditions that relate to that particular addition or renovation. So it's important that when you do obtain that Form 1, that you understand how to read it and that you carefully review it. And of course, if people need assistance with that, then they should certainly see a lawyer or a conveyancer. The Form 1 is inextricably linked with cooling off rights in South Australia. So I might just touch on that, seeing as we're talking about the Form 1. So once a person has, and I should mention that buyers should be aware that in South Australia there are some instances when cooling off rights don't apply, and I'll take you through that in a moment. But let's start off with the scenario when cooling off rights do apply. So once a contract has been signed and an accurate and complete Form 1 has been served, then a buyer has 2 clear business days cooling off rights. And in South Australia, if you wish to cool off, you need not give any specific reason for doing so. It's a statutory right to cool off in the event that you change your mind, or for instance you discover something in the Form 1 that you're concerned about, and you've decided not to proceed, then you can cool off. In terms of the cooling off rights and whether you do or don't have them, it will depend on the circumstances. So let me take you through when cooling off rights don't apply. So cooling off rights will not apply if you buy at an auction, okay? So in an auction scenario, normally if you attend an auction and you're the highest bidder, and provided that it exceeds the reserve price, when the fall of the hammer, you'll usually be required to sign a contract immediately, and you will be bound by that contract. You don't have any cooling off rights. So it's important, if you are going to be buying at an auction, it's important to be aware that by law the Form 1 document should be available for review at the agent's place of business for at least 3 consecutive days prior to the date of the auction. So it's advisable, if you are intending on going along to an auction with the intention of buying a property, that you do review the Form 1 during that time period. And in addition to that, it's required to be available at least 30 minutes prior to the conduct of the auction.
Yeah.
So you do have the ability to review the Form 1, but if you sign a contract at auction or you buy at auction, you won't have the ability to cool off on the sale. And in addition to that, if you go along to an auction and you bid, but the property is passed in, but subsequently on that same day before midnight, you go along and you're able to negotiate to buy that sale, you also won't have any cooling off rights in that scenario.
Okay, and given that there's no cooling off rights, probably a good idea to get your building inspections done, and if you need a valuation done prior, get that done.
Absolutely.
Because once the fall of the hammer, no cooling off.
That's exactly right. So if you're going to be buying at auction, you'll need to make sure you've got your finance in order. There's no hard and fast rules, but usually with a deposit it's around 10% unless you've negotiated something beforehand. So you'll be required to pay your 10% deposit on the day when you sign your contract. And of course, if you've got some concerns about whether it be the structural stability of the building or pest infestation and so on, you'll need to conduct all your due diligence before you go along to the auction. But Angelo, I'll just quickly mention the other circumstances when cooling off rights don't apply. You also won't get cooling off rights if you buy in the name of a company. So if you're buying under a corporate entity name, you won't have the benefit of cooling off rights. Also, in many instances, if you're buying via a process of a tender process, or if it's pursuant to an option to purchase, you won't have cooling off rights. And also, if the property is related to the purchase of a business, no cooling off rights apply.
So, Antonia, how would you cool off if you needed to?
Okay, it's important that when you receive a Form 1, there's a section in it, and it's right at the outset of the document, and it tells you how, or the methods that are available to cool off. It's essential that buyers cool off using one of those methods. And that's set out in the Form 1. So if a buyer decides that they want to cool off, it's very important that they follow those methods, and if they're unsure, they should obviously seek independent legal advice.
Okay. Antonia, you've just mentioned building and pest inspections. If you do have concerns about a property, where do you go from there?
Okay, that's a great question. Buyers would have noticed now that when they go along to inspect a property, they'll receive a document called a Form R3 entitled a Buyer's Information Notice. So when I mentioned those real estate reforms earlier on, there are a number of new forms and prescribed notices which have been introduced under legislation, and the Form R3 is one of those. So a real estate agent or a vendor who may be selling their property without using an agent is required to use all reasonable steps to provide a Form R3 to people when they are visiting or inspecting a property. So buyers who are out there may be feeling frustrated every time they walk into a property to inspect it. They're probably being offered the Form R3 over and over. It's important that people understand that real estate agents and vendors are required by law to offer that to you. That said, you are entitled to reject it, and you can certainly do so, and the agent's then fulfilled, or the vendor has fulfilled their legislative obligation to offer it. If you don't want to accept it, then it's your prerogative. The Form R3, Angelo, as the title obviously indicates, it's a buyer's information notice. So the idea behind this document is that it poses a series of questions to a buyer. It says to the buyer, you may wish to conduct certain due diligence before you commit to buying this property, and it's divided into 3 headings. The first is safety, the second enjoyment, and the third value. So just very quickly, in terms of some of the key questions that it poses, under the heading of safety, is there asbestos in the building? Does the property have any significant defects or salt damp? Are the electrical wiring, gas installation, plumbing and appliances in good working order? Then under the heading of enjoyment, it asks questions like, does the property have any stormwater problems? Are there significant trees on the property? What appliances, equipment and fittings are included in the sale of the property? And then finally, under the heading of value, are there any illegal or unapproved additions, extensions or alterations to the building? How energy efficient is the home? Are there water taps outside the building? Is there a watering system installed? And look, the list goes on, and it's certainly not an exhaustive list, but the idea behind that document is really to let a buyer know that there's certain investigations that they may consider conducting into a property before they buy. And so, of course, a buyer has the right to either, before putting in an offer, they may negotiate with the agent and vendor to conduct, for example, a building inspection report or a pest inspection into the property, and that can occur before they make an offer. Alternatively, sometimes the pest and building inspection report may occur during the cooling off period. And finally, there is an option that you may wish to make your offer subject to those things occurring and subject to your satisfaction with the outcome of those investigations. But certainly it's important that buyers understand that there is, if they've got some concerns about the structural stability of the building, or pest infestation or salt damp, whatever issue they may have or whatever concern they have, that they should conduct their own due diligence into those matters.
Very good. So, Antonia, if people need further information, where can they go?
Okay, well, there's a range of information available for people. The Real Estate Institute of South Australia operates a free public information advisory service. That's available to members of the public. It's those telephone calls are handled by experienced people with real estate backgrounds, and it's a free service. I should mention that service is actually funded pursuant to the Land Agents Act. Alternatively, the Office of Consumer and Business Affairs, they have an excellent website that has a range of information available, and they also put out a number of publications. They're free publications, and you can call OCBA and ask them to send you out some of those publications. There's also a very good website run by the Australian Institute of Conveyancers, the South Australian division. Again, that website has some excellent information about the Form 1 and about cooling off and the real estate process in general, buying and selling. So all of those resources are very good, and they're all available obviously free of charge to the public.
Okay. Well, in summary, what do you have to say about property and law?
Well, look, in summary, I think on the whole, these new laws have, I think, made a positive change to the way that real estate is transacted in South Australia. I think many of these laws have created greater safeguards. I think it's always important that if buying a property, if it's something that you are not experienced in, that you do seek advice, whether it be seeking advice from a real estate agent or a lawyer or a conveyancer. If in doubt, you should always ask. But look, I think it's fair to say that most real estate agents are happy to answer queries if you're unsure about something. So it's about opening those lines of communication and making sure that you're asking a question if there's something you're really not sure about.
All right, well, that's great. Thanks so much for that.
Thanks, Angelo.
Good.